Superior Court of Justice. Apparently, Superior Court of Justice governs by rules of civil procedure. Section 1021 says these rules apply to all civil proceeding in the Court of Appeal and in the Superior Court of Justice. But reality is different because all sections of rules of civil procedure are discretions of judges. There are many different contrary judgments in similar cases, and you never know the outcome of a case or motion hearing. For example, Section 1801A states that a statement of defense shall be delivered within 20 days after service of a statement of claim where the defendant is served in Ontario. Section 19011 says where a defendant failed to deliver a statement of defense within the prescribed time, the plaintiff may, on filing proof of service of the statement of claim, require the registrar to note the defendant in default. 19021. A defendant who has been noted in default is deemed to admit the truth of all the allegations of fact in the statement of claim. And Section 19031. The noting of default may be set aside by the court on such terms as are just. The word just in this section has a lot of contrary meaning in this court. While some judges and masters accept noting in default for a few days or weeks delay, a master ordered to set aside noting in default of a defendant with 2 years, exactly 660 days delay, without any reason. She only wrote that I know that they intend to defend all times. She didn't write how she knows and what was her relation to defendant that she knew what was in their mind. It is also interesting that despite that defendant in its affidavit wrote that court registrar informed them 3 times that they must file their motion within 10 days and they didn't file it. Master wrote that not filing the motion was due to delay of court system. It is ridiculous that the master, for defending the defendant, wrongfully accused the court. This lawyer angry master is obstacle and tragedy for justice system. In other sections, she clearly denied application of rules in her endorsement. In setting aside the noting of default, usually judges and masters award cost to unsuccessful party, which is plaintiff, because the successful party is wrongdoer who take advantage of court order, and sometimes they have no order for costs. But in this case, the master awarded the cost to defendant for its 2 years delay. This master, by lying under oath and other misconduct, brings down the credibility of justice system and is a good reason to show that putting the rules of discretion of judges and masters are totally wrong. Rules 21 and 25 are for shortened actions with when pleading is vexatious. But lawyers who have influence in the court use them to lengthen the process by bringing multiple unsuccessful motions under these rules. Rule 20 gives the judge power to decide in summary judgment when there is no genuine issue requiring trial. But corrupted judges misuse this rule to dismiss actions which have genuine issue requiring trial. For example, a judge wrote that if the court finds the presence of a genuine issue requiring a trial, the motion judge must then determine if the need for a trial can be avoided by using the new enhanced power under Rule 200421 and 22. This conclusion is against the right of the Canadians to have fair access to justice. The judge who claimed this power is a judge that, when appointed as a judge, there was an action against him in the same court which is impediment to appoint as a judge. Rule 57 is for costs of proceedings. Some judges and masters use this rule to show their power and punish the party who they don't like. Cost orders mostly have no base. Extent of chaos and anarchy in the Superior Court of Ontario is unbelievable. A judge who appointed with lies and had only 9 months experience appealed decisions of other judges with up to 15 years experience and reversed the costs order of other judges who were in my favor. Awarded costs out of his jurisdiction and ultimately changed the cost demand submitted by defendant and raised it by 65%. I don't know what happened during 6 days between our court hearing and issuing his endorsement that he changed everything he admitted in the court, and to justify his wrong decision he lied more than 20 times, which is serious crime. During past 4 years I had a lot of attempt to get court audio record and or transcript, which is my right, but he denied and ordered the court not to release it to prevent me from complaint against him. It is interesting that the Superior Court of Ontario, with the order of accused judge, hide the evidence of his misconduct. The case was so clear that this judge, on top of many lies, tried to induce that he has no common sense and doesn't understand basic concepts. He didn't understand the difference between confirmatory examination and a specific examination, while he did not ask for expert advice. A funny procedure in the court is preparing an order by parties who participated in the court from judge's endorsement. Sometimes judge or master ask one party to prepare order, and in other cases all parties must agree and sign it. One time the endorsement of judge was too short and only in 2 sentences. The defendant counsel tried to change it by preparing an order totally different from judgment. I didn't sign it and wrote to him that judgment is so clear and short that doesn't need to be changed by order. But he asked registrar of the court, and registrar changed the judgment of a judge only because of defendant's influence in the court. They told me that you can file a complaint in the court, but you have to pay costs for it.